Hi guys, welcome back to my YouTube channel. I'm Tebello Motwani. I am an attorney and the founder of a company called Collective Intelligence Legal Consultants. What the company does is provide a variety of legal services to SMMEs, and these services range from company registrations, trademark registrations, intellectual property advisory, drafting of various contracts across the board, and basically just providing support to individuals who want to go into business but don't know where to start. So on today's show, I'm just going to cover the things to expect or things to anticipate when starting a business. I'm going to try and cover mainly the legal side of things, and I'll just add in a few of my personal experiences here and there. I'll also just add in a few experiences which my clients have had, or just things that I've read about that would be interesting, to share with you guys, so that you don't make the same mistakes as everybody out there, or the same mistake as other entrepreneurs out there. First things first, I will start with, when you go into business, you first have to decide what kind of business you're offering, what kind of service you're offering, and then decide on what kind of structure you'd like to adopt for your business. There are different forms of business entities. The most common and simple one out there is a sole trader. That is, as Tebello, I just go out there and I start selling magwinya and acha, and there's just no registration to my company. I'm just a sole trader. You can have a business account or you can have a personal account, but there's no separation of legal entities. So that means that if somebody wants to sue your business, they will be able to sue you in your personal capacity, meaning that in order to make good the judgment debt, a creditor can come, the sheriff rather will come and attach your property in the event that you have a business debt that is outstanding and somebody has taken you to court for that. So that's the one thing to know about being a sole trader. There's no separate legal entity, and there's also no continuity of the business. That means that if you die, that is the end of your business. The second most popular form of business entity at the moment is actually a private company, especially you find that there's a lot of one-man owned private companies, and that's fairly easy to also establish. You, as the incorporator, just go to SIPSI, or you come to myself if you don't have the patience to do the SIPSI profile and just go through all of that admin. And basically what a private company is that there's definitely separate legal personality in that, meaning that in the event that your company is liable for X amount of debts, they will not be able to claim that from you in your personal capacity, meaning they'll exhaust the funds that are available in the business and they'll attach assets that belong to the business, but they won't be able to attach to your personal assets that are owned in your name. In the event that your company then doesn't have enough to cover that judgment debt, then your company will be liquidated, because you cannot afford to keep the business operating. I get it, you owe people, you owe suppliers out there and whatnot. So your company will eventually be liquidated if you can't commit to your debts. One thing that you need to know about private companies as well is that there is prospects of continuity, definitely. So the company can out-survive you. So if you die, the business can still carry on. Another thing about the incorporation of a private company is that if you incorporate a PTY Ltd, then you are just the incorporator, and what usually happens is that you elect yourself as a director. There's a further step to that. You need to then issue shares to make yourself a shareholder. So you being an incorporator is exactly that. You're just an incorporator, and you're not the owner of the business. In order for you to be a shareholder, you have to issue shares, pass a resolution, issue the shares, make payment into your business bank account, and then issue a share certificate with your details on it showing that you are a shareholder. in the beginning you can maybe transfer 50% to yourself, or 51% of shares to yourself, or 100%, so that in future when you want to take on a business partner or sell your shares in order to raise capital, then you will be able to, either if you own 100% in your personal capacity, you'll be able to sell those shares by concluding a sale of shares agreement, and then you will get paid into your bank account for those shares, and then you'll be able to issue the share certificates and give the person buying the shares their portion, whether it's 30% or 20%, whatever you decide. If you had initially only transferred 51% to yourself, then you will be selling directly from the company. The sale of shares will be directly from the company, meaning that the person who is buying the shares will have to pay into the company account. So you decide. But that's the one important thing to remember about private companies. If you are a owner, then you need to facilitate that purchase of shares. You need to do that in order to be a shareholder. Otherwise, you're just an incorporator or a director. Another form is public companies. I don't go into that a lot because a lot of the time public companies are established by a group of people, or an existing private company a few years down the line goes public. So I don't really deal with those enough to to share that with clients or to share that with you for purposes of this video. But that is another business entity that exists. We also then have partnerships, which is very, very popular. I can't stress this enough. Do not work with your siblings or work with your mom or your dad or a friend based on a relationship of trust. Do not work with a family member or with a friend or with anybody based on a relationship of trust. You need to conclude a partnership agreement to regulate that relationship. The partnership agreement will state the skills contribution by each party, the capital contribution by each party. It will also set out the obligations and the duty of each partner. It will set out how you guys will split profits. It will also set out what happens where there are liabilities. Most and foremost, partners are jointly and severally liable for all the liabilities of the company, of the partnership in your personal capacity. So in the event that you guys owe suppliers 100,000 and none of you and the partnership or the income of the partnership is not good to make good for that 100,000, then the court will be able to come and claim from each partner in their personal capacity. Very dangerous, but it happens. So yeah, as I was saying, you need that partnership agreement that also then sets out what happens if a partner dies, or what happens if a new partner comes in, what happens if a partner leaves. It will also set out things like dispute resolution. So in the event that partners aren't able to get along, how do they opt out of the partnership and so forth. So it's very, very important to govern your working relationship with a partnership agreement. This thing of, she's my mom, she's my sister, or we've been best friends since she was 10, she'll never do this to me. People change when they start making money. People become greedy, and you really don't want to work on a relationship based on trust. People change. People change when money starts coming in. So that is the most important thing to remember about your working relationship with people you trust. It has to be documented in a partnership. In the event of a dispute, I just pull out my partnership agreement and I say, look, this is what we signed upon. And if you breach the contract, then I can take you to court for that breach of contract. So it's very, very important to have a written piece of agreement. See an attorney who can draft a comprehensive partnership agreement for you. Come see me. I will draft a comprehensive partnership agreement. But it's very important that that working relationship is governed by a partnership agreement. Then another form of business entity is NPC, non-profit company. This is for basically people who are looking to register NGOs, non-profit organizations basically. It's, from my understanding, I'll double check, but from my understanding, social development gave that exercise, the registration exercise, over to SIPSI. So SIPSI now does NPC registrations, but you still need a NGO certificate through the Department of Social Development, and that certificate will also allow you to get a PBO number from SARS, which is a public benefit organization certificate from SARS, which is essentially a tax benefit, or usually if someone wants to donate to the NPC, then they'll ask if you have that tax exemption certificate, and then, or if you have a PBO number, then you provide them with that, then they can claim it as a donor of the NPC. So that process is slightly more costly on my end, because for the application for social development, I have to draft a contract, sit with you, find out the objectives of the non-profit organization. It can usually be for cultural activities, sporting activities, recreational activities. It can be for educational purposes. It can be for healthcare reasons. You can basically set up an organization for anything, a non-profit organization for anything, for awareness, like Autism Awareness Foundation, for a variety of things. But the most important thing is that the assets and the income does not vest in the owners of the NPC. You can derive a salary from there. So from the income that the NPC generates, you can get a salary from that. But the ownership of those assets and of the income does not vest in you as the founders. You do need you can't register an NPC by yourself. It needs 3 people. So usually for my own foundation, I got 2 other friends who I trust. There I am with the relationship of trust, but I got 2 other friends who I trust, and they sit on the board of the foundation with me. And yeah, so that's a requirement. Another form of business entity, I'm forgetting one. Personal liability company. Yes, personal liability company. This is usually an incorporation run by a qualified group of people. So for example, engineers, accountants, very, very popular with law firms. So usually if you see a company ending with INC, Inc., Incorporation, then they run a personal liability company. And while the thing that stands out the most about that form of business entity is that directors can, in certain circumstances, be held jointly and severally liable for past debts or past liabilities of a business, even once they've left the company. So it will just depend on when that specific liability was incurred, and if it's now found that you've left the company, you can still be held liable for that. So just a recap of everything: it's a sole trader, it's a partnership, it's a private company, it's a public company, it's an NPC, and it's a personal liability company. So very, very important to decide what kind of business entity you want to run. Obviously, after consultation, that's something I can advise you on, having taken various factors into consideration and what you or your business partners are trying to achieve. Then another thing I want to move on to or discuss in this video is the importance of a trademark. Guys, everybody, all the brands that we trust own trademarks. And a trademark is basically a symbol which distinguishes your company, your service offering, your brand from that of competitors. That's why Adidas has their own logo. That's why Native Child has their own logo. That's why Sister-in-Law has their own logo. That's why Collective Intelligence has their own logo, so that we can establish or distinguish ourselves rather from our competitors. Think of a situation where I didn't perhaps have the sister-in-law logo registered as a trademark, and a year down the line, somebody is using a clenched fist holding the scales of justice, and I want to, assert my rights and say, this is my trademark, this is my logo, I've been using it, and I then run to an attorney to help me register the trademark, only to find that this person has registered that trademark, which very, very closely resembles mine. And they've been gaining a competitive advantage through the use of that logo and trademark. Maybe they're based in the Eastern Cape or the Western Cape. And people who've seen my online presence through sister-in-law think that me and my competitor are associated, or we come from the same company. So she's been consulting under the name sister-in-law because she's been using a logo similar to mine. If I want to assert my rights, it's going to be very, very difficult to do so if I don't have a registration certificate showing that I am the owner of this trademark. One thing to note is that even if your company is registered, you still have to register a trademark. So a registration of a company does not mean that your trademark is automatically registered. The company register and the trademark register are two separate things. Company registration is a company registration. Trademark registration falls under intellectual property. A trademark is also an asset to your business. That is literally how your clients associate your brand with basically the logo serves as a stamp of approval to say, yes, this is X brand, this is the quality that you can trust, these are the ingredients that are used in the product. That's why Coca-Cola has a logo. That's why McDonald's has a logo. That's why KFC has a logo. You know that wherever you see it, you expect a certain quality, you expect a certain taste, you expect a certain reputation around the brand. So you definitely want to do the same thing for your brand. Your brand, your trademark name, your slogan, your company name, your product name, those are all assets of your company. Your intellectual property is an asset of the company. So you also want to show investors in the future that you are aware of, your intellectual property rights and that you've done research. And it's a nice thing to show investors that your intellectual property is taken care of. Then they also know that there's a degree of, or basically that ownership, then you can enforce your rights against somebody who is gaining commercially from your trademark, when you actually have somebody who's pumped a lot of money into your brand. So do not underestimate the importance of registering a trademark. It's very important. For me, for example, I registered Collective Intelligence trademark and the sister-in-law trademark before I even knew that I wanted to have anything around that name. When I registered sister-in-law, I didn't know it would be a company. I didn't know I would ever be able to commercialize that name. But now I have. And imagine if I hadn't, and somebody else out there is calling themselves sister-in-law, and everybody thinks that we're associated. Meanwhile, they're busy offering subpar legal services and tarnishing the name in other provinces. By the time I get there, people will be like, no, we've worked with sister-in-law before and we got scammed, or whatever the case is. So it's very important to register your trademark. You also don't want a situation where you've been using a name for a period of time, or you've been using a hashtag for a period of time, and all of a sudden a big company, a large corporation starts using your hashtag, and you're like, wait, what's going on? This is my trademark. How is it your trademark when you haven't protected it? You definitely want to protect yourself against that. Rather than register the trademark, not use it, and then 2 years down the line when someone else starts using that hashtag, you can say, oh, hello, big corporation, I see that you've been using my trademark. I'm the rightful owner. I will sell it to you for 100,000 Rand, and then we can facilitate the transfer of that intellectual property to you. So a trademark is an asset to your business. When you register a company name, even if you're a sole trader, when you start trading, register whatever it is, whatever product it is, whatever service you're offering, whatever tagline that is, unique, register it as a trademark. It's very important. You also will think that you've come up with a bright name or a unique name, only to find that that name exists in the registrar. So in the beginning, when you're still trying to find your feet, deciding on a name, before you start even, paying for packaging, for advertising, for website design, check that that trademark is available. Check that that name, is available as a trademark. Check that that slogan is available as a trademark. Check that it's also available as a company. Knock on Tebello's door. Ask questions. Let's do those trademark search. Let's do the company search. But make sure that before you start investing heavily into a name, you have protected it by means of registering a trademark, and that you've protected it by means of at least registering a company, but something to show that I, as the Bello, I own this mark. It's very, very important. Then while we're on the topic of intellectual property, you can also, if you design something, that this world hasn't seen before, whether it's aesthetic or functional, you can also then register a design. You go to an attorney who's qualified to register a design. If you've come up with a brand new idea or brand new set of ingredients that taste like Coke but are not Coke, for example, and don't taste like anything, and it's your secret ingredients, 11 spices and herbs, then you can register that recipe as a patent. You'd have to see a patent attorney for that. So again, it's just to show investors that you've done your homework, you heavily invested in the brand, and it is another motivation for them to take you seriously. Then once you've sorted out all that admin, company registrations and trademarks, you also want to consider the kinds of contracts that you want to have as a startup business. If you are a manufacturer or a producer of goods, then you want to have a manufacturing agreement. The manufacturing agreement will set out things like specifications, will set out delivery times, delivery locations, payment terms, invoicing terms, date of inception of your working relationship. It will set out date of termination, if any. Usually there'll be an initial period, and if your working relationship is going on, you can decide to extend that period. It will also set out what happens if there's a dispute resolution. Usually there's a dispute resolution, especially with manufacturing or producing goods. So you definitely want to have that contract in place, especially for when things go bad. The manufacturing agreement will also set out the quantity, the quality, and any other unique aspects that need to go into manufacturing a certain product. So that's the first agreement you want to have. You can also have an exclusive manufacturing agreement, which will mean that in a particular location, you are the only person who is allowed to manufacture a certain product for the person you're supplying. Then if you're in the distribution chain, you want to consider having a distribution agreement. You can also have an exclusive distribution agreement. For example, if you want to branch out to Namibia, Botswana, Lesotho, you can then say, I'm the only person allowed to sell this hair product, or distribute rather this hair product in Botswana, and then you produce that agreement which shows that you have distribution rights in Botswana. If you then find out that the manufacturer has secretly been giving someone else in Botswana the tender to distribute those products, then you do have a claim based on breach of contract. Then you want to have a supply agreement in place as well. Supply agreement is also very, very similar to manufacturing agreement. It sets out the quantity, the quality of the products, when it should be delivered, where it should be delivered, how much it costs, how invoicing must be effected, how payment must be done, and what happens in the event of a dispute. And it also sets out intellectual property rights, that whatever you are supplying doesn't infringe on another person's trademark or on another person's intellectual property rights. And also just sets out issues of confidentiality. So those are the main agreements you want to consider having if you're a supplier, a distributor, a manufacturer. So manufacturing agreement, supply agreement, and distribution agreement. I always tell clients not to focus too much on the name of the agreement, but rather focus on the contents of the agreement. So once again, it's important to consult with an attorney so that you can table out exactly what you want to achieve from that contract. Then if you are a service provider, freelancer, or if you're an influencer, then you want to consider having a service level agreement in place. So either a service level agreement or an influencer agreement, which has become very popular nowadays. I've drafted quite a few of those, or a talent management agreement or independent contractors agreement. So if you are a freelancer, influencer, or service provider, then those are the agreements that you want to think of having. These agreements basically also just strictly set out that there is no relationship of employer-employee between the client and the service provider. With a service level agreement, you can also set out project timelines. So by a certain date, I need 100 pictures produced or 100 pictures printed and spread on a canvas. You can table how payment is to be effected, which bank account it must be sent into, timelines, or I already said timelines. You can set out dispute resolution, very important. I've heard of way too many freelancers complaining about not being paid on time, or being sent to a wrong location. So basically, if there is a dispute resolution clause, then you can basically resolve that dispute based on the agreement itself. Then independent contractor agreement, also the same thing. Project timeline set out, payment terms, invoicing terms, what is expected, the obligations of the parties, and dispute resolution clauses as well. Influencer agreement is going to set out what is expected of the influencer, on which social platforms they must post, how they must conduct themselves in public, how they should be brand ambassadors of the brands they're working with. It also sets out the brands that you're not allowed to work with. So for example, if you are a brand ambassador for makeup, for MAC, you then can't do Connie Transform campaigns. Or if you are ambassador for Dove, you can't then take on a Pond's campaign, or any other campaign in the beauty related industry. So that usually sets that out. And then it also has payment terms, that if you post 7 times a week and at the end of the 30-day period you must submit an invoice using X reference, then that influencer agreement will set that out. Also very important to check that there is a dispute resolution clause. Influencers are in effect freelancers, so they definitely do come across situations where they don't get paid, or they didn't receive the right products but then they're still expected to post, or whatever the case may be. So very important to be aware of that as well. As an influencer, you also want to make sure that in the agreement it states exactly what you should and shouldn't do in terms of the Advertising Standards Authority. You want to abide by those laws. I know that influencers are expected to put sponsored or hashtag ad, or to just show that is a sponsored post, or it's a promotion of sorts. So you definitely want to familiarize yourself with that industry specific legislation, because you can also be held accountable as the influencer even if you didn't know. I like telling clients that the ignorance of the law is no excuse, and that stands for influencers as well. You can't say you didn't know a specific provision was illegal. And then another contract that you want to consider, if you're looking to employ people, then you're going to decide whether or not it's going to be a fixed term contract. Fixed term contract is very similar to a independent contractor agreement, because usually that says that the person will only be hired for a specific project or for a specific period, and then once that period comes to an end, then the contract terminates. So it will either be 3 months or 6 months, or until such time as there's been an extension to make sure that the project deadlines are met. Then if you're hiring someone on a permanent basis, then you want to have an employment contract that usually sets out the duties. So what is expected of the employee. It sets out study leave, maternity leave, sick leave. It sets out their salary structure. Any commission is also set out there. Sets out their working hours, when the contract starts, how to terminate it, how long their probation is, what they should be aware of during probation. So an employment agreement is slightly more comprehensive than a fixed term agreement, because this is someone you're going to keep on board for a long time. So you definitely want to make sure that you have that in place as well. Remember though that not having a employment contract with someone doesn't mean that they are not an employee. Definitely intention over form. And if a party or if the court, for example, determines that there was an employer-employee relationship and that you have breached that, then you can also be held liable as an employer if you don't follow the necessary labor relations legal process or the basic conditions of Employment Act. So very, very important to have a written contract. Then the last contract that I'll discuss is a lease agreement. If you're looking to rent out premises for your products, maybe a store, a storage place or warehouse, or if you're looking to just conduct your services from an office space, then you are going to receive a commercial lease. This differs from a residential lease because residential leases are regulated by the Rental Housing Act. So the one thing that stands out that is different from a residential lease to a commercial lease is that with a commercial lease, the landlord is not obliged to keep your deposit in an interest-bearing account for your benefit. So even if they do keep your deposit in an interest-bearing account, there's no obligation on them to give you that interest at the end of your lease term. Whereas with a residential lease, the landlord is obliged to keep your deposit in an interest-bearing account. When your lease ends and there is then no claim on anything you may have broken, on any damaged property, then the landlord should give you your rent, your deposit, together with that interest that accrued in the interest-bearing account. The same is not applicable for a commercial lease. There's no obligation on the landlord to give you the interest that is derived from your deposit. And then another thing for a commercial lease, even for a residential lease, but because I'm speaking about for businesses, for a commercial lease, you want to ensure that before you take occupation of the property, there is what we call an inspection. So you need to do this inspection either before or during, but definitely before so that you are protected. Then you and the landlord must have a list. The door frame was cracked here. Draw a picture, draw an X next to the door frame. The window sill, there was glue eshotang, draw an X there as well. Then go outside and say the door handle was cracked or broken, blah, 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 blah. And that inventory will also be signed by you and the landlord. And when your lease term ends, you look at that. Well, if the landlord then says you're only getting half of your deposit because I had to use some of the deposit for the door frame you broke, you can say, no, where's that inventory list? When I first took occupation of this property, we did an inspection and this door frame was broken, meaning I don't owe you for this door frame. So it's very, very important to do that inspection before you take occupation of the property. Last thing on commercial leases is that you want to ensure that the property or the premises are suitable for their intended use. Obviously, if you're opening a salon, you're going to need a working geyser. You're going to need proper plumbing. You're going to need you're going to need sockets in different places of the salon. But if you are, for example, just going to be offering legal services, you don't really need a working geyser. You can boil your water with a kettle if you need to make tea, and you don't really need to make sure that the plumbing is fitted for different basins. So you need to make sure that the property you are going to occupy will be able to be used for its intended purpose. I think that brings me to the end of the contracts that small businesses or people looking to go into businesses should have. I'd definitely like to hear from you, so please comment below if there's anything you need clarity on. You can also email me on collective-intelligence.co.za, and I encourage you to also check the website to see the service offering that we provided Collective Intelligence Legal Consultants. That's www.collective-intelligence.co.za. If you enjoyed this video, I encourage you to please share it with other entrepreneurs, share it with anybody who's looking to start a business as well, and just spread the word. Spread the word, because it's always important for entrepreneurs to start their businesses on a good legal footing, because it costs more money in the long run to unbundle a mess than to just be proactive. I always encourage clients to be proactive rather than reactive when it comes to legal advice and legal services and the legal running of their businesses. So give this a thumbs up, guys, and I really hope you enjoyed it. Do comment below. I would like to hear your feedback, and I hope to see you soon in real life. Bye.